Good morning, good afternoon, good evening. Hello, goodbye. Hello, everybody. I am Jason Weiss. I am the host of the Ask Jason Weiss show. As many of you know, I am both a legal consultant, an attorney, a coach, and a mediator. And mediation is something we're going to be talking about today with my esteemed guest, Stanley Zamor. But before I let Stan talk, I need to go ahead and put the disclaimer out here. Although I am an attorney, nothing that we talk about today is legal advice. Should you seek legal or financial advice, consult an attorney directly. Nothing in here you should rely upon as anything advising you on what to do. This is for educational purposes only, and no attorney-client privilege has been established. So, on the screen with me right now, much sharper dressed man than me, always has been. I've known this guy probably 21 years, 2020, 2002, I think we met, 2001, 2002. We were both working at a prestigious law firm, and Stan was the guy that if you wanted something done, Stan was the guy. He was always running around, always doing. He ran our softball team, our football team, our mediation department, our paralegal department. He did it all. And that's where he is today. The mover, the shaker, Stan the Man Zamor, who is a certified mediator and a qualified arbitrator. And he is a trainer, a coach, and a lecturer in the field of what we're going to call ADR, which is alternative dispute resolution. So without any further ado, my fellow Giants fan, Mr. Stan Zamor, the media.
Thank you, Jason. That was so nice, so complete. I'm digging it. But of course, I have to wear the power red tie to impress you. Always try to impress you, my man. So that's
you never need to impress me, Stan. Your actions speak louder than words at all times. So what I will say is this: Stan is an alternative dispute resolution trainer, and he is also a mediator and an arbitrator. So we're going to go right in there. And we're gonna start by knocking out common misconceptions. So the first thing is, Stan, let's talk about the difference between mediation and arbitration, because I get the question all the time. Oh, I don't want to go to mediation because I don't want a judge telling me what I got to do. That's not mediation. So let's start there. Stan, explain to our audience mediation, arbitration differences.
And what I usually hear is, I don't want to go to no meditation. I don't need meditation. And this mediation. And the difference between the two, pretty simply, actually, first of all, there's something called the continuum of ADR, the continuum of alternative dispute resolution. So imagine a slinky, right? A slinky, remember back in the days? I'm showing my age right now. A slinky, right? Or a rainbow, even better, okay? A rainbow. On one side, you have partnering and negotiation. How do you have one of those already?
And for those of you that are seeing the show, I got the slinky right here, and I swear it was not pre-organized. So there is the slinky.
Okay, I have to admit, I'm a little clairvoyant. I kind of see things, and I kind of knew that. So I kind of put it out there. I'm being serious. Anyway, so imagine a rainbow or a slinky where you have, on one side, you have negotiations, two individuals, two entities that are in conflict, in discourse. And on the other side, you have adjudication. Someone that you selected or the court house selected to give you their decision as to how they think the case should be decided based on the facts as they're presented and the law. Okay, in between the negotiations and adjudication, courthouses and such, jury trials and such, you have a bunch of other processes. One of the processes, which I think happen to be the best of all of them, but they all have their places, is mediation. What that means is a third party, a neutral, that facilitates a conversation between two disputing entities or parties as to their case, as to their wants and needs, and assist in identifying issues, assist in exploring alternatives to a solution to their issues. That's what a mediator is. They're neutral and they're also impartial. And impartiality is a funny word. I'm not going to get into it, but that means there's no favoritism or bias in word, action, or appearance. So this is a person who just has no concern other than let's bring people together and have this conversation. That's how I framework it, because I think that's the better way to framework it. Conversation about your case. They have no adjudicatory authority, which means they cannot make a decision for you. In fact, according to certain rules of Florida Supreme Court certified mediators, certified and court-appointed mediators, on the rule 10.370, look it up yourself, A and C, they're not allowed to give you, ethically, they cannot give you their personal or professional opinion. They cannot do it. So although Florida's pretty strict, it's awesome because you really have an individual, if they're trained in conflict resolution, to really sit people down with their attorneys, or if they're not represented by counsel, to help you look at your case, but more importantly, look at solutions to your case and be creative with you and find solutions that work for the parties. Contrary to that, or conversely, would be an arbitrator. An arbitrator is an individual that is either selected by the court or appointed by the party, in the sense that if you're going to be arbitrating through, let's say, Florida, the Florida system, the Florida court system, then a judge will appoint you, okay? Meaning, like, I get appointed over time for non-binding arbitration. They will appoint you. Or if you are arbitrating through another organization, like let's say AAA, the American, the American Arbitration Association, or FINRA, which does institutional securities, stocks and bonds, things of that nature. They may have a system that you can say, hey, listen, Jason, we have an issue, and according to our contract, either an employment contract or a business contract, there's a clause that says, if we come up to a dispute, we've agreed, we'll do it through arbitration and not litigation. We'll arbitrate. Why would you go to arbitration? Because arbitration is private. Again, if you're in the court system and the court selects an arbitrator through a list they may have, whatever they decide can be private. Okay, meaning no one knows the exact details of what they adjudicate. Okay, in the court system, it's public record. It's open. All right, but the details what the arbitrator found will not be shared. If you're going to arbitrate through a system like the AAA or FINRA, as I told you, it's private. Okay, what's public might be who the arbitrator is, who's going to be making a determination. Meaning, you present your facts to me. You present your facts to me, provide me case law you want me to consider, provide evidence you want me to consider, witness testimony, whatever it may be, and you all agree that my decision is what you're going to accept. That's going to be private, which is why you see a lot of big companies in their employment contracts have arbitration as a clause as opposed to litigation, because litigation, courthouse, is public. Okay? Now, mediation is also confidential, meaning...
I personally don't like arbitration in most settings. I don't. I find it, like you just said, very expensive, very time consuming, very grueling, and I don't think it's that much faster than going to court. However, in the construction industry, I think that it is a much better, smoother process to do arbitration in construction. And the reason I say that, and this is my own belief, is that you're dealing with something that's so complex. Is it a latent defect? Meaning that you can see it? Is it a hidden defect? Meaning you can't see it? Is it something to do with a specific contract, a specific clause, a specific this, a specific that?
A change order that was not done appropriately or properly.
Correct. So when you're getting to these real technical things, having an arbitrator that knows construction is game changing. Now, arbitrators, they don't need to be attorneys, correct?
They can't. I would say a high percentage of them are, like 80-90% are, and then you have some like me who are not. But I do have a level of expertise in areas like employment intellectual property and construction and commercial litigation. So I get selected, insurance as well. So I get selected for those cases because, frankly, for over 20 plus years, I've done a lot of work within the legal industry in different areas of law that people feel, okay, he knows this stuff. That's a rarity. I'm a unicorn like that.
Which is another reason why you are Stan the Man, because, you are fortunate enough that you didn't have to go through the grueling of law school to get to do my favorite part of the law, right? My favorite two parts of the law are helping other attorneys find their way and mediation. And those are, and to me, they're very similar because in mediation, you're helping others find their way. And what I want to just go back to the listeners and just to make sure that they heard you correctly, mediators don't get to say, party A, you're right, party B, you're wrong. No. What we say is, party A, well, what happens if this? Or have you thought of that? Or, getting resolved.
What you think will happen if they prevail? How does trial look like the first 5 days? What are you willing to go through? What brought you here? And you know what? Real quick correction with that. It's not that I didn't do 3 years of law school because my undergrad is legal studies. And it was grueling because, thank goodness, my undergrad and my paralegal certificate, which is 2.5 years I took, was actually taught in the law school of Nova Southeastern University. So I didn't have to go to law school, but trust me, Iraqi cases, shepherdizing cases, writing case briefs, doing jury instructions. You're not going to name many things I have not done that a 30-year or a 45-year attorney has done.
Oh, and I can personally attest to it because I remember nights that we were both working all through the night when we were down in Miami working together. All of this, we would grab a slice of pizza, run back to the office. So I get it. The only thing you did not have to do is sit through the grueling. It's first year of law school that really kicks your butt. Second year is better. Third year is easier. And if I tell my wife all the time, if we were able to make it through first year of law school and the LSAT, then we could probably accomplish anything. And one of the things that I talk about in my book called Shit They Never Taught You in Law School, The Survival Guide to Navigating the Law, plug, is the fact that what law school is, and it's a full-time job. But again, Stan is a mediator and arbitrator. He's appointed by courts. He's on panels. He's used by insurance companies. He speaks the language. And he teaches lawyers how to be a mediator, how to be an arbitrator. He's certified. He's certifiable, just like the rest of us. But this is a gentleman that, gets the benefit of, to me, the best part of the law, which is mediation. And one of the things, and I don't have the answer, I'm sure you do, Stan, but Florida, and I'm only talking Florida, you cannot get to trial in a case in Florida without jumping through hoops if you haven't gone to mediation. Yes, you can file a motion with the court saying, Your Honor, we don't want to go to mediation because before we filed, we had an informal mediation. Your Honor, if the two people are in the same room, I fear safety for somebody. If there's something here, if there's something there, if there's something. So talk about what you think. A, do other states require mediation? And B, what do you think are the benefits of going to mediation before you go to trial?
First, thank you for that. Florida, I think Florida has the best system of alternative dispute resolution, which includes mediation at its forefront in the country. To me, and I wrote an article about this, and I speak about this all the time, mediation in Florida is like Formula One racing, while the rest of the country is like NASCAR. Nothing wrong with it. Both requires an amazing sense of eye-hand coordination, very quick vehicles, but really completely different. And Florida is more unique, and Florida is more precise into mediating for, or using that process for Joe Public and for the court system to reduce its caseload. It's very different. And I think it is the best process because less than 5% of the cases go to trial. You are not going to have a divorce, construction, HOA, elder law, intellectual property, wills, trust, and estate. I could go on to 5 different areas of law. You're not going to see the trial unless you're going to try mediation first. People have tried to dispense with mediation all the time, but the judges, especially talking like over, I was on a panel of other neutrals, I'll say other neutrals, and some judges, and some of these judges were of the 20 jurisdictions in Florida. I think 2 or 3 of them were the admin judge, the administrative judge of those jurisdictions, right? And they were like talking about over 700,000 cases, criminal and civil, filed in Florida. And I know it's really close to 1 million cases. That's a lot. And during COVID, when the courthouses stopped, when everything stopped for 90 days or 5 or 6 months, people were still filing. So in 2020, there was an uptick in filing, not a downslide in filing. And guess what? Judges that had docket sheets of 800 cases, which is already a burden, we're now looking at 2,000-3,000 cases. And it was like, oh my gosh. So this panel I was on was this conversation as to how we can alleviate and how we can respond to all these cases. And it was mediation being the key. So you're not going to get out of mediation. But what you want to do is make sure you find a mediator that knows the ethical rules. Because I'm sorry, I'm just going to say it. I train judges. I train very, very good litigators. I've been doing it 35 plus years, board certified in all kinds of areas. I train other professionals that may negotiate all the time and now want to get into the field of ADR or mediation. And I'm telling you, I got testimonials from 100 plus individuals who they get it wrong. They did not know. They did not know that it's supposed to be done this way.
I took your class during COVID. One of the benefits of COVID was I was able to take your class. I got certified through your class. It was great because I was able to sit at home for 5 days straight and do it, but I took it. And I know that one of the things we did in the class is I intentionally role played negatively, but there were things that I learned that I didn't know a mediator could do. And I remember speaking to you afterwards saying, is that really something a mediator can't do? You're like, Jay, of course they can't do that. And I was blown away with some of the stuff. And yeah, look, I'm practicing law 24 years. I learned something new every day. Every day. And when I took your class, I learned lots of
new. That, though. You're open for that. You're a different type of attorney. I hate to say it, but it's true. Most attorneys aren't like you, which is why I wrote that book. Those attorneys don't see litigation and mediation the way you did. Very, very few did. And I know tons of lawyers. I know many judge friends that I call friends, and they do it the right way. But when you're talking about how many lawyers are there in Florida?
Too many.
Over 110,000. I know that. About 110,000. Okay? How many mediators? You don't know. I know. 5,646 as of today. I'm telling you these stats to let you know.
And 2 of them are on this call. Look at that.
I'm telling you that because just so that people understand what you can really gain from this fantastic process, if you understand it better, is you have 5,646 certified mediators in the 5 areas of mediation. It's only 5 areas.
What are those 5 areas? Yes, please.
Tendency, appellate, circuit, family, and county. 5 different areas.
One of the things, ladies and gentlemen who are listening, mediation, stand correctly if I'm wrong, but mediation does not occur in a criminal case.
No.
They have diversion programs, they have counseling, but it is not that you could get a mediator like Stan or myself to mediate it. It is different. It's a different program, so take commercial out. But family and civil, 100%. And you got to get certified in each of them. County, civil, family. I'm only in civil. But
I have 3 of the 5. I could do all 5. I could train in all 5. But I only select family, circuit, and county. Those are my forte. Those I like the best because it really is good for me. But I trained in all of them, and I'm an assistant trainer in most of them. That's what I was saying. Of the 5,
one of the things I want to say about mediation, though, is where I, as an attorney, when I like mediation, is because I hear from the client all the time. I just want to tell my story to the judge. I just want to get in front of the court and I want to tell my story. Reality is, when a piece of litigation, how many times the person involved is going to go to court is probably one time, and that would be for the actual trial or because they want to go see a hearing. But otherwise, individuals, companies, they don't go to court. They might get deposed, and their opportunity to tell their story to someone that's engaged and cares is at mediation. They're going to see this young man right here on my screen, and they're going to say, Stan, here's what happened. And I was doing this, and this guy did that, and this dog did this, and blah, 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 blah. And Stan is going to listen, and he is going to make you feel like he's invested. He cares, because he does. And he's going to listen to what you say, and he's going to say, ma'am, sir, I'm so sorry you had to go through this. What an awful experience. How can we get you out of this? What are you looking for today? If I were a genie in a bottle, what would be your wish? And he listens. And then he says, okay, so your wish is that you want $1 million for today. Ma'am, what is your actual damage? $17. Okay, so $17 gets you whole. Where do you come up with the other $990,000? Well,
were you listening to my last case last week?
Dude, I get this all the time. All the time. Yes, I was in a car accident and my medical bills are $5,000 and my car was fully replaced. And yes, my insurance went up $20 a month for the rest of my life, but I'm entitled to $1 million. What's your damage? I went and saw a chiropractor 3 times and got adjusted. Anything else? No. What's your out of pocket? $57. And I'm making this up. It's completely.
No, you're not. So that sounds pretty accurate to a lot of the.
So, but I want $1 million, right? So the problem I have with that client as a lawyer is, look, I've told my client, it's not $1 million case. It's not a $500,000 case. It's not $100,000 case. This case is worth 15 grand on a good day. Yeah, but no. I want to tell my story to the judge. Okay. Before we get to the judge, I get to tell the story to Stan. And I'm not afraid of what my client is going to say because mediation is confidential. So they could say, I was drunk in driving the car. I was stoned in driving the car. And it's all going to come out. And Stan will probably say, oh, ma'am, is that part of the case? Was there an accident? No. I was secretly stoned. Nobody knows. Okay, great. Could it come out at a deposition? Maybe. Oh, have you been deposed yet? Not yet. That's next week. You know, they're going to ask you that question where you were under the influence at the time of, of the accident. Oh, now what do I do? Maybe I don't need $500,000 anymore. Maybe now I only need 100,000. And a lot of the time is what the mediator says in response to put you in a different hat. Think differently.
Different mindset. Some mediators would take that scenario you just created. Let's go with that. And I'm sorry. I got a training tomorrow I'm doing. It's called Mediation is My Superpower. And it's going to go through different types of understanding of superheroes you might see from Marvel Comics or DC, whatever, and how aspects or attributes of those characters are in mediation that I think can be exhibited once in a while. For example, Spider-Man, as before we started, I said, with great power comes great responsibility. That's also in religious texts as well. But I think it's important to understand why I'm even using that, because mediation is the only time you have a third person listening to your case in a level that you will never have before. And you, the party, there you go. See, I know that. I knew that. The parties can tell me everything they want, whether their attorneys think it's valuable or not valuable. They can tell me anything they want to give me some perspective. And what I can do with that is do a technique. I'm not going to give you all my techniques. Come to my class and learn. But one of mine is strategic empathy, I call it. Strategic empathy. One of my abilities, one of the things that I can do, or I think I'm very strong at, is even if the other side are suits with a risk assessment sheet and said it's only worth blah, blah. I'm really effective at getting them into the process and looking at Mr. and Mrs. injured for $5,000 to be seen as an individual and not just as a number or something to check up on. And good mediators who understand conflict resolution, not being a lawyer, being a former judge, adjudicating, and let me tell you how bad your case is, that's actually unethical to do. And I could show you some case law, I could show you some grievances where mediators were actually suspended. They were grieved, they were complained about because they gave parties the law the way you just described. Your case is worth this. Now, there's reality checking, there's a technique you can do that's similar to that, but the way you do it is the art of mediation. But the way most lawyers do it is you have no damages here, lady. Boom, 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 boom. You can't tell someone they have no damages as a mediator because you don't know, because you're not the adjudicator of fact. It's not your role to be that. But what you can do is go through their perspective and understanding of the case and the way they see themselves. And ultimately, what are their wants? What are their needs? What are their walkaways? Let's work with that. Let's work with those two things.
And I often, a word I use a lot in mediation is, or a question is, can you please explain? Because that gets the ball rolling. That gets the juices going. And when the attorneys try to start to explain to me, I go, time out. I'm asking your client. Please explain to me what happened. Please explain to me what your damages are. Please explain to me what you would like here. Please explain. And that's the path I like to go. Because like you said, as a mediator and as a coach and as a consultant, they're all the same to me, right? I can't tell you, Stan, you should wear a blue tie with that outfit because blah, blah, blah. I would say, Stan, I really like your outfit and I really like that tie. Do you think any other ties might complement that well? And you'd look down and you'd be like, look, I got some blue pinstripes in here. Maybe blue would go well. I didn't think of that. That is our job, to get the thought process going.
What you just did is so funny because
if it's good, I learned it in your class. If it's bad, I didn't learn that.
The way you just went through what you did is something that people don't realize. Again, I teach and instruct advanced negotiation and mediation advocacy techniques and skills. And the way you just walked someone through that is what most attorney-mediators, former judiciary-mediators don't understand, don't get. So that's a level of very, very good and advanced awareness of how to walk an individual through the process. Don't do that. Don't do that. Why is he doing that, Ma? Don't do that.
That's because I took your class. And Stan, not to interrupt you, but I like to interrupt you. If people wanted to take a class or learn more or get to see you more, you're talking about all these different programs. Is there a website that they can go to other than finding Stanley Zamor, Z-A-M-O-R, on LinkedIn, or Googling Stanley Zamor and mediation or arbitration? Zamor ADR expert at gmail.com, effectivemediationconsultants.com. For all of you listeners and all the people that are watching this and all the people that will see it after, check that out. I mean, this is great, to go ahead and learn negotiation in everything in life.
Family.
If you are, bingo, Stan and I each have children, right? Each of our children, it's about a negotiation. I know for a fact he's got some very intelligent kids. I know this for a fact. And they will say, hey, Dad, can I have $50? Because I want to go ahead and fill up the car with super gas. Because in super gas, Dad, you taught me it's better performance. It cleans the car. I have less of a chance of a problem. They lay it all out. Stan's like, here's 100.
I do. That's here's 100. Double that. Don't come back tomorrow. But real quick, even in family, I mean, yeah, they can Google my name, Stanley Zamor. A bunch of things comes up. On the screen I see is the actual website where I do consulting. I get phone calls at this week, Sunday, 8 p.m. from a person that was given my information by a family therapist. They're going through a very tumultuous divorce, and that is actually besides the commercial work I do and the instructions and consulting and 8-hour CME classes, complex family cases, divorces is my forte, because I just feel that, again, I'm not about getting a settlement. I'm about, let's go through a process of changing the behavior on how you communicate. If we can do that and wrap around that, we can hopefully find better results. After you spend, and I know this for a fact, unfortunately, after you spend $100,000 on this lawyer, $80,000 on this lawyer, after you put your child and yourself through levels of therapy, you're not done. You might have, depending on the age of your child, you have a lifetime to deal with that other person. So one of my seminars is called Negotiating with the Enemy, and it's focusing on family-like cases where that best friend you used to have is now your worst enemy, and they know everything. They know all the triggers. They know how to get at you, get to you. So how do you communicate with that individual? How do you get them to meet you where you want them to meet you to get to better solutions? And that's tough to do. But again, not a skilled neutral that has subject matter expertise in the law, which is important. It's important, but a person that has expertise in the process of conflict resolution, the process of what I call strategic empathy, the process of getting that person. And I practice and I do a hybrid style of negotiation, a hybrid approach. There are 5 approaches. I won't get into them. But my approach allows you to emote to some degree, just a little bit, to get it out. And once it's out, let's get to work.
So there's 2 things I'm going to pick up on there. You talked about subject matter, jurisdiction, and all this. You don't know how many times I get a phone call from a family, a friend of a friend, a family, my mom, whatever. Jason, this guy just got arrested for doing this and doing that. Yeah, I don't practice criminal law, but you're a lawyer. But I don't practice criminal law. Let me send you over to so-and-so who does. But Jason, I trust you. I don't practice criminal law. Don't ask me a criminal law question, right? I can't help you. I'll get you to so-and-so who's great and she's top notch and that's who I would use, or, this type of person or that type of person. And the other thing is that you mentioned I think you said your worst enemy. Is that what it was? Your worst?
Yeah. Negotiating with your worst enemy.
Negotiating with my worst enemy is standing in front of the mirror.
Oh, absolutely.
I am my worst.
Emotion is huge. So a lot of what I do or train people to, hopefully, again, I'm never going to say having subject matter expertise is not important. It definitely is important. But to be an effective, and I use words specifically on purpose, effective mediators is gone through and engaged if you have process. Like, you know what? I changed the name of my company because about 15 years ago, when I started my own private mediation company, it was called I Mediate Consultant. Yes, I know, playing on the iPhone stuff. I Mediate Consultant. That's what consulting. That's what it was. And I was doing a training with a room full of lawyers. And
I'm sorry that you had to be in a room full of lawyers.
Crazy. I'm not going to say that. I love it because to me it allows me to help them transform their thought process into something different. So what happened was, as I would make my introductions, hi, I'm Stanley Zamor, and I'm in front of all these people, and a half hour in of the very first hour of introductions, after that I get into, this is 8 hours, a long time, pre-COVID, so it's in front live. We talk about, I touch on ethics a little bit, and one of the guys who identified himself as an attorney from Boca Raton, and actually he's a pretty famous attorney. Everybody, if I said his name, you would know who he is. And he said, Stanley, great guy. I love you. Smell good too. Great tie. All this stuff you're talking is great, but there's no way. All the things are already, I can see you, this kumbaya stuff. doesn't work. If you're going to be effective in negotiations, you have to tell them like it is. You better tell them how bad their case is, how good their case is, and they like that. My clients come to me for that. And I said, oh, I just smiled and said, all right.
But wait, that's why your clients go to you as the lawyer to hear that. They don't go to the mediator to hear that.
You were thinking of mediation
research. I often use mediation when I'm going in as an attorney so that the client will hear from the mediator and know what to expect. Well, have you thought about this? And what happens if that happens? And oh my God, and even what you said, if you're going to trial for 5 days, can your business survive the 5 days without you? Do you have the staff ready to go? Who are the people that are going to come in and testify on your behalf or against you? What do they look like? What do they, and to go off you, what do they smell like? What do they look like? Is there a language barrier? Is there a difficulty in getting to court? Are you going to have to? These are all things that come into play.
This is how I changed why I changed the name of my company, because of this guy. I just smiled and said, all right, cool. And as we walk through hour 3, 4, we're at hour 5 now, and I start hitting them all, but specifically him, with how would you handle this? And he's giving me his attorney-media response. I said, grievance, complaint, here's a statute, complaint, here's other people that just did what you did, and guess what? Complained about, grieved, unethical. I started hitting, he's like, well, how am I supposed to be effective if I can't tell them how bad? And the last 3 hours were all about conflict resolution technique. Even what you just said, how you just went through what I started talking about, walk me through your understanding of court, walk me through this, and the third. That's a technique, actually. And he was like, I had no idea this type of abilities were there. I had no idea I could expand my toolbox to be. I thought it was all about what I've experienced as a lawyer who's negotiated, a lawyer participating as a lawyer in mediation, and me now being a mediator. And I opened him up so much so, I still get emails from him saying he completely changed how he litigates in negotiation efforts, and he's become a way better mediator because he opened himself up to conflict resolution skill sets. So that month, I changed the name of my company from I Mediate Consultants to Effective Mediation, because you can be ethical and you can be effective if you understand these rules well.
And you can be empathetic, because you use that word, empathy too. That's important. You don't want to go in and say, the lady who was in the car accident and all this and all that, and she lost the car that she saved her entire life for and all this and all that. Man, that stinks, but you didn't have insurance. I'm sorry, you're SOL. No. Oh my God, you worked so hard. Let's see what we can do. You got to show the people that you're involved, you're invested. And that's the big thing. And people don't get that with trial. Like, judges can be phenomenal, don't get me wrong, but you said it. If you have a docket of 800 and that's normal, and your docket's now 2,000, I apologize on behalf of all judges, but they're not reading every single pleading and paper that's there. And if you're lucky, you got a clerk that's reading it and summarizing it for the judge, but at the end of the day, they can't. It is impossible. As much as judges want to, they can't. I want to read this new book that my friend told me to read. It's called Start With Why. I've had it a week. This is the first time I'm even picking it up. Why? Because I don't have the time. I want to. And speaking of time, although there was so much I still wanted to talk to Stan about with the future of mediation and AI, we don't have the time. So I'm going to have to do this, Stan. I'm going to have you back in a couple of weeks. We're going to do this again, and we're going to talk about that. But I always end the show with the hardest ask.
What's the hardest ask?
And here we go, right? If you were a superhero that is currently out there, who would you be and why? I don't care gender. I don't care height. I don't care fit. Just who would you be and why?
Holy smokes. That was a hard one. I thought if I was a superhero, who would I be and why?
Yep. Like, I'd probably want to be Deadpool, right? He's obnoxious. He's crazy. He can live forever. He's invincible. I mean, the only other one I like, you have a kid who's named that, so it would be
Professor X. I that's a tough question. I did not know that was going to be a tough question because I'm into comic books and.
Okay, fine. What's your favorite comic book that you're reading?
I'm gonna answer the question because my favorite is Wolverine, Wolverine and Spider-Man. Those are my two favorites. But if I'm saying who would I want to be, and this is tough, would be Professor Xavier. But that's hard because Professor Xavier has the ability to do telekinesis, but he also has the ability to understand everyone. He can get into the mind, create blocks. He has the power to every human in the world with cerebral maybe, whoop, and shut them down. Can't use their arms. Can't see. He can completely control their minds. He does not use that power for that. He uses it to create hope. He uses it to bring out the best in people. He sees something. Maybe have a mutation. If the mutation is internal, like secret power, or the mutation is physical due to an ailment or a disability, he sees the value in you and helps you bring it out. And that's what
with great power comes
responsibility. With great power comes responsibility, which is again from my favorite comic book character, which is Spider-Man. But back to Professor X, and then we can leave. Again, he takes everyone for who they are, where they are. As a mediator, it's not about, even if I have a very strong knowledge in 5 to 10 areas of law, I'm not going to try to teach everyone where it is or help the lawyers teach their client. I'm going to come where they are, come to their understanding, so we can come together to a solution that works best for them. So AI, we can't talk about, but you guys have to look at a company, Cognitive Resolution Solutions. Cognitive Resolution Solutions. Full disclosure, I have an interest in this company. Been working with David Puckett for years on this thing, and we have an idea on how to the ethical utilization of AI in mediation. We know what happens in New York when those lawyers had AI, ChatGPT, write that brief for them.
Yep.
And it hallucinated. People are trying to use, and this happened to me 3 times in the last 2 months, trying to use AI in a mediation via Zoom. And I said, I will not use it. Look up my recent articles. I have a whole article based on that. We're not going to do that because to me, that's
so what we're absolutely going to come back, Stan, in a couple of weeks on this show, not a couple, but a handful of weeks. And we're going to talk about AI in the law profession and mediation and all of that. But unfortunately, I'm getting we're done. So thank you all for listening. Thank you all for attending. Thank you, Stan, the man Zamor, for being here. Let's run his contact information one more time on the bottom so that everybody can get a hold of him. Zamor, ADR expert at gmail.com, effectivemediationconsultants.com. Google him. Check him out on LinkedIn. Check him out all over. And if you want to learn how to become a mediator, and now you've learned that you don't need to be a lawyer, dude, take his class. If you're just anything in life where you're doing negotiations, take his class. How's that for a plug, Mr. Zamor?
Thank you. There are some restrictions, but we can talk about that when you call me. 954-261-8600. So let's go.
Ladies, gentlemen, and everybody else, have a wonderful day. And thank you again, Stan, for being here and being my guest. Hang out after the show, Stan.
I will. Thank you.